I'm really pleased to introduce our first speakers. As proper regulation is key to the success of the industry and the topic since the beginning of our conference, it is my pleasure that Michael Manz, Head Financial System and Financial Markets from the State Secretariat for International Financial Matters, and Katharina Barth will open this virtual day. They will talk about the Swiss regulation approach, shine light on the DLT law, which came into effect this February, and examine what regulatory challenges remain. So really happy to have you with us, Katharina and Michael. And Katharina, please take over.
Thank you, Nicolo. Thank you. And hello, Michael. I'm really excited to be able to speak to you now because there's just been a flurry of activity this year, and we have a lot of ground to cover. And I want to start basically in February of this year. Switzerland passed a distributed ledger law, and we saw a flurry of activity on the back of that. I wanted to ask you, could you walk us through what that law is good for? What was Switzerland's intention in doing so?
Yes, sure. And before I do that, I would like to thank you for the invitation and hello to everyone. And it's a pleasure to be here and to talk about the Swiss regulatory framework. Maybe just one general remark on the Swiss DLT bill. Actually, we always call it DLT bill, but it's not a DLT bill. It's actually a blanket act that changes 10 different laws in Switzerland. So it's not one blockchain law, but it's a bunch of specific changes we made. And it has been adopted by Parliament in last September. And as you mentioned, the first part of it entered into force on February. And this part, let me talk about this one first. It's a very important part. It was a change in civil law in the Code of Obligations. And it allows us the introduction of new securities. We call it register or so-called ledger-based securities. So it's possible to have to tokenize any claim now in Switzerland, be that a share, bond, claim to a commodity, to whatever, and to transfer it by means of a digital register. We did not. The law is that's an important issue, an important point. It's tech neutral, as tech neutral as possible. So there is no provision what is a good or what is sufficiently good registry. We do not have a provision that calls for it needs to have 77 nodes, and so everyone tries to do something with 77.5 nodes. So we have rather an abstract technical prescription. For example, let me just mention 2 or 3 things. The integrity must be protected by means of technological tools, and the holder or the creditor must have full power of disposal of the asset, and it must be fully transparent. It must have access to all information directly on the blockchain or the DLT or linked to that, and without any assistance of an intermediary. So the government or the law leaves it upon the parties to determine what is a good registry. But other than that, it allows a lot of new opportunities to trade and to transfer assets, claims on a blockchain or a DLT.
Now, there's been, I think, just an enormous amount of focus in the overall industry about Bitcoin. And I know that this law kind of enables or goes a lot further than that and encompasses quite a lot more. Could you maybe give us a few examples of what you could envisage that is possible under this law?
Yeah,
sorry, the series of bills.
Yeah, the series of bills. I mean, the first part I mentioned actually solved the problem for the so-called security or asset tokens. Not so much for Bitcoin. For Bitcoin, it was not a problem. The transfer was always and other Bitcoin and other payment tokens or native tokens. This hasn't been an issue, but for asset tokens, there have been kind of impediments such as the written requirement, which was necessary, and now no longer is. So I think in this part in the Code of Obligations, it's mainly a huge progress for security tokens. And while there is a lot of focus on Bitcoin and the like and cryptocurrencies, we also think there is a huge potential in this kind of assets. So some companies I know at the very beginning, even in February, issued their own shares on the blockchain. Some also had original ideas like tokenize a fine wine on the blockchain. But ultimately, you can tokenize and trade anything on a blockchain by means of digital or these so-called ledger-based securities. And in the long run, I think it's not upon the government to make forecasts what is the best business model and the use you can make of it. and we always have a so-called bottom-up approach in Switzerland. I work for the government and I like working for the government, but we do not think that the government is best suited to run a startup. So actually it's upon the startup, but on the industry to develop ideas and to profit from this new environment. But we now have a legal certainty. It is possible to transfer legal claims, any kind of claims on a blockchain and DLT, provided this DLT has some minimal requirements.
Well, that's a lovely handover when you say it's not upon the government to say how this happens exactly. But we're almost 6 months into the first step of this since February. Can you tell me what, in your view, now needs to happen in order for this to basically bed down into real business?
Yes, I think now that the legal framework is here, I think what is most important now, and as I mentioned, we think it's now upon the industry, and it's happening, I think, and I observe, it's now to develop standards and best practices. Of course, if you're a tech firm or a tech freak, it's not difficult to issue something on a blockchain for you, but if you want to do it on a broader scale and also for small and medium enterprises, and I think there is actually the potential to raise public funds, it's always a bit, there is a hurdle because it's very costly, and it's actually a potential for smaller companies. But as they're not all experts on the blockchain, they need kind of standard procedures, prospectus, kind of anything standardized procedures. And I know the industry is working on that. For example, the CMTA, the Capital Market Technology Association in Switzerland, but also the Swiss Blockchain Federation has been or is working on several approaches to standardize processes. I think you need like a handbook, so it's easy and simple to issue, for example, a share on a blockchain. It's only if you are really a company of expertise, it's easy for you to do that. But other than that, you need kind of guidance, and I think that's now important that the industry develops this kind of guidance and best practices and standards, so that not everyone has to invent the wheel again.
So if I'm understanding you correctly, in terms of the regulatory framework is standing. And of course, Switzerland has a long tradition in most types of regulation, including financial regulation, of applying a more principles-based approach as opposed to a strict rules-based one. Do you feel that will continue going forward and in order to kind of build this bridge between regulatory framework, business reality?
Yeah, I think the principle-based approach we have is very important. By the way, this was also the reason for which we thought it is not necessary to have a complete blockchain law and to change everything. We think all in all, and there has been a large report back in 2018 by the government on every detail on the Swiss legal requirements. We think overall our approach is quite flexible and principle-based, and that's very important when a technology is very rapidly evolving. So usually in Switzerland also it takes 2 years to implement a change in a law, and technology is much faster, so we cannot regulate every detail in the law. We think that's a very promising approach, and it has proven to be effective in the past, and we think we will continue this way. Maybe just one additional remark. When I say principle-based, there's sometimes a misunderstanding. Principle-based does not mean weak. I mean, of course, you have to abide by the rule. For example, pretty strict AML-CFT rules. And principle-based rather means not every detail is fixed in the law, but we leave it then up on FINMA and the supervisory authorities to deal with the details, and they are quite competent in these matters.
But you're also placing an enormous amount of trust in any institutes or crypto firms themselves. Is that correct?
I mean, we place a lot of trust in any company, but of course the rules are here. Whatever activity you do, for many of those you need a license, so you have to ask FINMA, and you cannot be active before you have that license. So ultimately, it's still as soon as you perform an activity that needs a license, you have to get that license from FINMA, and that's of course in the end a decision by the authorities. Yeah.
Okay, now let's talk about what happens next. Like I say, it's been a huge year, and it will continue to be a huge year in regulatory terms in this space. The next thing that's coming up is, of course, the trading system law for distributed ledger-based systems. Can you tell me a little bit about what that law will basically make possible or enable that is impossible today?
Yeah, so this is now, as I mentioned, overall the DLT bill is is fixed. It's 10 different. It has amended 10 different laws, and the first part was in February. The second will enter into force in August, and in this part we will introduce a new license. Actually, this also needs some changes at the level of ordinances, and this will be public soon, very soon, I must say, in the upcoming days or weeks. And this one introduces a new so-called Dlt Trading Facility. And this facility has actually two purposes. On the one hand, it facilitates something which has been possible so far, but it makes it more specific and more tailored to the DLT needs. So, for example, if you operate a system that does trading and post-trading, any clearing, settlement, or custody services, then today you need different licenses. You have to create different companies, and this is possible. It's not something that is not possible. But in the new license, we know that the technology is going to converge trading and post-trading, and so you can do that with one license. I mean, other than that, it's not a license light. It's the full license. You have to same risk, same euro approach in Switzerland, but you don't have to have two companies, and it's just less complex. This is one innovation. Maybe the other one, which is really new and which has not been possible so far, is you can also give access to retail customers. I mean, any company or any natural person can participate in in trading. This is not possible today because all the existing licenses also only provide access to regulated financial intermediaries, and it's not actually kind of DLT-like if you again need an intermediary to participate. And this new trading facility will allow direct participation by natural persons. And because of that, of course, there are some specific provisions. So that the DLT system has to take care of AML, CFT, and so on, and some investor protection issues. But it will be a new license that offers opportunities to directly participate in a multilateral trading of DLT or of security token securities.
That is quite exciting. That's, I believe, also a global novelty there. Can you maybe walk me through a little bit of the what you see as the more important developments that are also part of this series of bills coming into effect? What else is coming up?
Yeah, I think one other there are many smaller elements, but I think the three major one has been this: the new registries, the DLT trading system, and the third one I would say we have a change in bankruptcy law. So in the debt enforcement and bankruptcy framework of Switzerland. And so far there has been a legal uncertainty when you have any tokens, be that payment tokens, Bitcoin, whatever, if you have them in a custody service and in the unfortunate case where you have a bankruptcy, it has not been quite clear if these assets will be segregated from the bankruptcy estate. So which was a bit annoying legal uncertainty, and this will be removed as of August of this year, and there'll be a new provision that makes it very clear under some circumstances. For example, the asset always has to be disposable for the client, so we cannot do sec lending or anything like that. But if it's directly allocated to an individual, or even if it's in collective custody, but it's quite clear who owns which portion of it, and if you fulfill a number of requirements, then it's clear these assets, the virtual assets, the tokens can be segregated. And we think this is pretty important, both for service providers, but also for the customer. So you have access to your Bitcoin or whatever currency, whatever the worth of it is, but you don't have the risk of bankruptcy of the custodian. This will be eliminated, and this legal uncertainty will no longer hold as of August of this year. And I think this also opens opportunities in the custody services, for example, with cold storage and so on. I think for those, it's an important innovation in the Swiss legal framework.
Okay. Now, if I understand you correctly, that means that things like Bitcoin would be treated very similarly to securities, shares.
Yes, provided it's client business, of course. If the key is with the institution, then not. But if it's a client asset, then it's exactly treated like a share with all advantages. Of course, it also comes with a disadvantage. Of course, you don't have the deposit insurance, but you can't have the piece of the cake and eat it. You can't have all. So it's more treated like a share, which in our view, or gold, which in our view also makes sense.
Yeah, I understand. Let me ask you, Switzerland's had a Fintech license for a little over 2 years now, I think. And that's kind of paved the way a little bit to where we are now. Can you maybe tell me a little bit about what experience you've gained from that in regulatory terms and how that's translated to what's happening this year?
Yes. So the fintech license was introduced in 2019, and the idea was something to have something between zero and the full banking license. This was a particular gap in Switzerland because previously, before you, even if you only collected money from 20 people, 1 franc per each, you actually would have to apply for a full banking license. And so we have now introduced some steps between 0 and 100% so that you can grow into a license. So first, there's a little sandbox, although I do not particularly like the word sandbox. It's more a threshold. If you are below 1 million, if you collect less than 1 million public deposits, then you don't need any license. If you go up to 100 million, then you can apply for this fintech license, but it comes with a number of restrictions. So we cannot do the whole maturity transformation. You cannot invest those assets and pay interest, but it can be attractive for payment service providers that needs to be regulated, but that don't need the full weight and the full obligations of a banking license. And so far we have had three licenses have been granted. I've heard also, we can also read that in the annual report by FINMA, that there are others are pending other requests. And the experience has been, this can be quite useful, but we also have experienced that some providers, they preferred from the beginning to have the full banking license. That's of course a choice you have. So we also have 2 new banks that are specialized on crypto services, Signum and SIBA, that decided to get the full banking license because then you don't have these restrictions in your business. And they have been granted this license by FINMA.
Okay, so equal footing to traditional finance, a traditional bank, Swiss bank.
They can do everything that a traditional Swiss bank can do. Yeah, as I mentioned, with the fintech license, you can do payment services and different things, but you cannot be active in credit business. You cannot go beyond 100 million. You do have a number of restrictions. Yeah. Okay. Which makes sense, of course. Yeah.
I'm curious, in the US at the moment, I think there's a little bit of a debate in terms of crypto-based funds. And I wanted to know, what is Switzerland, or could Switzerland do to make providers of crypto funds to make their life a little bit easier? Is there anything in the planning on that level?
Yeah, but maybe as an initial remark, we also have, of course, we had looked at the Collective Investment Scheme Act. We did not think that we have to change something particularly for crypto, because it's possible. You have to abide by the same rules as any other fund. But irrelated to crypto assets, there is a change, an ongoing change. It's this year in Parliament, and it will enter into force probably some next year. We are going to introduce a limited qualified investor fund. This is a fund that is only available to professional clients, not for retail clients, but which has less restrictions than a usual fund, and which doesn't need a license by FINMA. So the asset manager still has to be licensed and supervised, but the product itself doesn't need a license. And the purpose here is to reduce time to market. So it will be a niche product, but it can be useful for some specific complicated funds. And crypto is of course one application, although not the only one. And then the idea is you have less time to market, but a limited only to qualified investors. And once you have experience and more time, you can also still request an authorization and then also distribute it to any clients. But then you can already go to market with innovative products, and we think that's something that could also be interesting for crypto funds. Yes.
Okay, but that is something that where retail investors are not allowed. Is that correct?
No. If for this one, it's not allowed for retail investors. Yes, okay. But you always have you can always ask for a full authorization, but then you have to. Again, you can't have it all. Then you need the time to market. If you have a complex fund, then you have to wait for the authorization. But you can go in 2 steps. You can first have the limited qualified investor fund, collect some experience. If you think the product is useful and popular, then you can also ask for a authorization, which takes more time. And then you can also go to retail investors.
can you tell me a little bit about how the reception has been, in your view, from the industry since February?
Yeah, so, well, of course, I think the reception has been quite good. But I also must say, of course, we have had a close collaboration with the industry. Even for that report back in 2018, we have discussed with dozens, if not hundreds, of crypto in the cluster with
So
lawyers,
don't want to interrupt you, Michael, but
small companies. Yeah. Sorry?
Just to be clear, the 2008 guidelines laid out, which were one of the first, I think, to really define and sort of pave the way for how Switzerland would treat digital assets. Is that correct?
Yes, the 2018 report by the government, and also FINMA, even early in 2018, also had issued its famous classification of tokens, which was if the utility, the payment, and the asset tokens, which I think now is pretty standard. Yeah.
So I didn't mean to interrupt you, but you were saying that was a helpful roadmap as well.
Yes.
I now see Nicolo popping up on my screen,
Yes.
which I believe means that we probably have a couple of questions to go through.
Correct. So first of all, thank you very much, Michael and Katharina, for this discussion. It's pretty interesting what Switzerland was able to put up and what we have now as tools. So one question, we are now asking questions from participants. With everything that we have now that Michael talked about, one question is still, what can Switzerland learn from the DM case, like the Facebook stablecoin, to ensure in the future that stablecoins stay in Switzerland, or projects like these stay in Switzerland or in Europe, and not just benefit from the established and intensive licensing process to then continue their business in other markets around the world?
Yeah, of course, maybe some couple of words on DM, but I think you also have an SEC commissioner. You can also ask a question afterwards. But I think DM, of course, as everyone else in the world, it took us by surprise, this project. It's okay, you wanted to come to Switzerland. We know probably because we have some expertise in this field. And but also everyone knows here at the conference, of course, it was a huge discussion about Libra and then later DM that has not been related to Switzerland, but rather basic question: what is the role of money? Is that a public task? Is it a private task? And so on. And there have been many questions and many issues. And as a reaction to that, the Libra and later DM Association decided to rescale the project. So only US dollar, and we have focused on US customers. And then it was quite a logical step. If you're focused on US clients and US dollar, then you move to the United States. And that's what I have decided. But I don't think it has been an issue of the Swiss framework. Switzerland's framework would have worked. We would have had a solution. And FINMA also already got a very positive feedback also by other authorities. They took everyone on board, also from the US, UK, and European Union, to discuss that even before a license was granted. But it was in the end the decision of the company for the reasons I mentioned, because the project is now different, no longer global, it's US focused. In which case, of course, if you then it makes sense to move to the US. But I think for our framework, we got a positive feedback. It might have worked, it would have worked. But it also, one lesson is, of course, if you want to have a global product, then you have to abide by everyone's rules. That's just a fact. So we cannot. Yes. And you also have to abide by the US rules, by the European rules. If you're in Switzerland, by the Swiss rules, in Japan, by the Japanese rules. That's just something the industry has to live with, and global projects, this can make it complicated. Yeah.
Okay, thank you for that. So then the next question there is, let's go away from like DM, but to the market in Switzerland. So if you could wish something, so we have now a law, or the law is coming in place. So the next question is, what would you wish if you could say? I mean, we have everything in place, and now what? So if you could frame that, what do you think would be the most important next step now?
Yeah, of course. As I mentioned a little bit earlier, I think the framework to experiment and to run startups is here. I think it's now upon the industry to develop solutions, to improve technologies and develop business cases And of course, well, I'm not the expert, but if I had a wish, of course, you also need to find mechanisms that work equally well, like the proof of work, which intellectually is a very fascinating mechanism, but which consume less energy. I think probably for mass adoption and scaling of this technology, this will be an important innovation. Yeah.
Good. Then I'm looking on the watch. Half an hour is really fast. So first of all, thank you very much to both of you to be part here at the CfC Virtual Day. So thank you for your insights. And as we discussed it before also, you will now be part of the virtual networking day. So the participants, now we have to switch the camera, will be or will have the chance to meet you also in the virtual networking room, and they can ask also their questions. So thank you very much to you once again, and see you hopefully soon.